Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about the presumption of regularity of the authority of certain officers to act. So let us go straight to section 93b, which says that every person described in the particulars filed with the commission pursuant to section 36(4)c, 319 and 337 of this act as a director, a managing director, or secretary of the company, or represented by the company, acting through its members in general meeting, board of directors, or managing director as an officer or agent of the company, has been duly appointed and has authority to exercise the powers and discharge the duties customarily exercised or performed by a managing director or the secretary of a company, exercised or performed by an officer or agent of the type concerned. This enacts the actual, apparent, or ostensible, customary, and usual authority of directors, managing directors, secretary, agents, and officers. Third parties are entitled to presume that they are being duly appointed. This is why I call this the Freeman and Lockyer section. The reason I call it Freeman and Lockyer section is because if you can remember the case, K was purporting to act for the company as the managing director. K was not appointed as managing director, but there was such an ostensible authority on K, so much so that the court interpreted such ostensible authority to mean that he was appointed. Do you understand? So in this case of section 93b, where you have certain officers who have either the actual authority, the apparent authority, that's ostensible, customary, or usual authority, it will be deemed that they have been duly appointed. So third parties are entitled to presume that they have been duly appointed, and if it turns out that they are not, companies remain bound, having held them out as its duly appointed officials and having the usual or customary authority of an office held by them. Companies cannot thus plead that any of the director, managing director, secretary, officers, and agents weren't duly appointed. You can see why it is the Freeman and Lockyer section, because it tells you that when you put a person out and then third parties have relied on it, there is a presumption that that person that you put out was duly appointed. If it then turns out that the person wasn't in fact duly appointed, you cannot argue that you did not duly appoint him because you had already put him out. Now this section is in sync with section 286, which says that the act of a director, manager, or secretary are valid notwithstanding any defect that may afterward be discovered in his appointment or qualification. When we read this in line with section 276, it tells us that the company is bound by act of person whom it holds out as its director, even though he has not been duly appointed as such. Now section 90 shows the implied or apparent or extensible authority of an officer or agent of the company. When you read all this in line with section 93b, it tells you that while there is a presumption under section 93b that any officer that is being held out is such that has been duly appointed, then you read it with section 286 that says regardless of any defect in the appointment, the act of such director, manager, or secretary is valid. You read it in line with section 276 that tells us that the company would be bound by act of anybody he holds out to be its officer or agent or director. Do you understand? So all these are read in line to commensurate the presumption of regularity of the authority of officers. Do you understand? So what this rule basically is saying is that when you get to the front of the mansion, in the analogy that I painted earlier, and somebody purports to act as an officer of that particular mansion. Either the person has actual authority, apparent or ostensible, customary or usual authority. When such person is put out by the company to be its officer with either of the authorities that I listed earlier, then there is a presumption that you can make that that person has been duly appointed. So you have to read through the provisions of section 93B, and not just that, section 286 and 276, to be able to come down to this assertion that if there is anything that you do with that person, the company would not be able to deny the person wasn't his officer. There is a presumption that he was duly appointed. Not just that, any liability that occurs from such transaction will be such that the company will be liable, whether or not the person was appointed properly or not. Since the company put him out, there is a presumption that the person was appointed properly. So that is the presumption for the authority, that is appointment of certain officers. So the next that we are going to would be the presumption for the genuineness of document.